Let's go over how to succeed in small claims court. First, let me say, I am not an attorney, nor do I play one on TV or YouTube for that matter. Nothing in this video or any of my videos is to be considered as legal advice. These are merely my opinions based on my experiences as a professional investigator. Also keep this in mind, the procedures for small claims courts will vary based on jurisdictions, so checking with your local court for specific rules is essential. Small claims court was created to allow individuals or businesses to resolve disputes involving modest amounts of money in a relatively informal setting. Most small claims courts allow for claims in the $5,000 to $10,000 range. Most will also allow you to file for larger losses within reason, but they will only allow the max judgment of that $5,000 to $10,000 depending on the rules and the laws of that particular county, state, or other jurisdiction that oversees the court. The first step you need to take before you ever file the claim in court is to determine the eligibility of the claim. Ensure the disputed amount falls within the court's monetary limit for small claims. As stated, this will vary from jurisdiction to jurisdiction, so it is incumbent that you do some homework first to make sure you know the limits. This is one of the biggest mistakes many people make, filing a claim for too large of a loss, then the court automatically denies it. You also need to ensure you are within the statute of limitations for your particular claim. This is something that will, again, vary from jurisdiction to jurisdiction. The statute of limitation is a law that sets the maximum time after an event has occurred that you can start legal proceedings. The purpose behind statutes of limitation laws is to ensure legal disputes are brought forward in a timely manner, thus preserving the integrity of the evidence and the witness testimony and preventing the perpetual threat of litigation. This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. Next, we move on to how to prepare for filing the actual claim. For this, the first thing we need to do is to identify the parties to the case. The parties to a case are the individuals, entities, or groups involved in a legal proceeding. Typically, there are two primary parties to every case. The first is the plaintiff. This is the party who initiates the lawsuit by filing a complaint alleging wrongdoing by the defendant. The second party is called the defendant. This is the party against whom the lawsuit is brought, accused of causing harm or breaching legal obligations. Keep in mind, in some cases, there can be multiple plaintiffs or defendants in any court case, including a small claims case. So before filing, you must ensure you have the legal names and addresses for all parties involved. Next, you need to gather all the evidence for the case, such as contracts, receipts, photographs, emails, letters, texts, and other correspondences. You will need to provide copies of this evidence to the court. When you do that, make sure you have backup copies of everything. Now you have to quantify your claim. In other words, calculate the exact amount of money you're seeking. Filing the claim with the court is the next step. This will include completing the forms the court provides. Make sure you fill out the claim forms that they provide as completely as possible. Leaving things up in the air for interpretation is another huge mistake people make. You won't get a chance to introduce new evidence or facts in court, so you need to ensure you have everything filled out as completely as possible with the initial filing. There will also always be a filing fee, which again will vary from jurisdiction to jurisdiction. Once the filing fee is paid, you will file the necessary forms and evidence to the court. This filing process may be online, might be in person, or both, depending again on the jurisdiction. Next, the other party or parties to the case must be notified about the court filing. In order to do this, you need to hire a process server to serve the papers the court provides to you to the other parties, the defendants in the case. The documents will usually include a summons to appear along with a complaint that indicates what the allegations include and any evidence that you have filed with the court. Again, the documents' names and types will differ depending on each court's requirements, but the court will usually give you pretty good instructions on what each document has and what needs to happen. I recommend you hire a process server or the sheriff's department to serve the papers, but it could be someone else. You need to ensure, though, that you have a neutral third party serve the defendant with the complaint and summons. Once the other party or parties is served, you will receive a proof of service, often called an affidavit of service, for each individual that was served. You will need to file these proofs or affidavits with the court before any upcoming hearings. I always recommend doing this as quickly as possible, just in case there's a problem with any of them, so you have time to rectify those issues. One of the biggest problems I see is the defendant not getting served within the legal time limit to be served. For instance, most summonses here have to be served 15 days before the court hearing, so you need to make sure you hire a process server soon enough to get it served within that time frame. I recommend having 1 to 2 weeks to allow for service, just in case the defendant is out of town or it takes multiple rounds to get them served. So it would help if you asked the court to set the court date out like 4 weeks to give you plenty of time to get the other parties served. If there is not much time to get them served, you may have to pay rush service fees, and even then, there is no guarantee the process server can get them served. I also do not recommend using the old give them as little time as possible ploy to try to get an advantage on the case. This seldom works well, often causes more stress, and can backfire and be more detrimental to the case. In the event you cannot get the other parties served in time, you can usually ask the court for a new court date. This will require filing more papers, usually another filing fee, and the court will then need to issue new documents like an alias summons to be served on the other parties. After everyone has been served, you need to start preparing for court. First, you need to do this to organize all of the evidence. Prepare your evidence in a logical order for presentation. You may receive other evidence from the other side as well, so make sure you include this in your organization. If you have witnesses, you need to arrange for any witnesses to attend the court hearing or provide sworn statements if permissible. This may require you to have them served with a subpoena to give testimony or fill out a waiver to be served. Some small claims court do not require friendly witnesses to be subpoenaed, but you must list them on your filing documents. Make sure during your preparations for court you do not prep or coach your witnesses. It is fine if they know why they will be there, but do not go so far as to tell them what to say or how to answer questions. Remember, most small claims courts will allow the cross-examination of all witnesses after they have given their initial testimony. Next is the court hearing itself. Here you will be given a chance to present your case to the court. Make sure you do this as clearly and simply as possible as you state the facts of your case. Present your evidence, explain how you calculated the damages, and bring up your witnesses at the appropriate time. You must also ensure you are professional, polite, address the judge as your honor, and never interrupt anyone. This isn't TV court. There is no yelling over the other party or witnesses or the judge for that matter. Doing this can quickly get you in hot water and jeopardize the entire case. When you present your evidence, make sure you understand what evidence is admissible. If you're unsure what is or is not admissible, check with the court before filing your case. It is not the court's responsibility to review your evidence when filed and tell you whether it is admissible. The day of court is not a good time to find out that your evidence is not admissible. Some examples of what may not be allowed are things like hearsay. For example, suppose a witness tries to testify about what someone else told them rather than something they personally experienced or observed. In that case, it's likely to be considered hearsay and ruled inadmissible. Irrelevant evidence is evidence that is not directly related to the facts of the case at hand and may be considered irrelevant. For instance, information about the defendant's character or past actions that do not directly affect the case could be ruled inadmissible based on irrelevance. Privileged communications are also usually not admissible in court. Examples of privileged communications include conversations between attorney and client, doctor and patient, and between spouses. Make sure your evidence is presented in a chronological or thematic order that supports your case. When the other side presents their case, make sure you are prepared to state objections to the evidence where appropriate. For example, state objections if the defendant introduces improper or irrelevant evidence to the case. If the other side starts a character assassination against you, then object to the relevance of the statement. If a witness states he or she heard from so-and-so that you did such and such, then object based on hearsay. Once both parties have finished their arguments and given any closing statements, the judge will make a decision or may also decide to make a decision later and mail out that decision at a later date. If you won the case, the court will issue a written judgment in your favor for the amount owed. Now you must collect on that judgment. Hopefully the defendant just pays up and moves on, but that is not always the case. After a judgment has been awarded in small claims court, the winning party is now referred to as the judgment creditor. I always recommend to first communicate with the debtor to arrange payment. If the defendant, now referred to as the debtor, does not pay willingly, you can explore enforcement options such as wage garnishments, bank levies, or property liens. You will also usually need to go back to court and get what is called a writ. A judgment creditor may use several types of writs to enforce the judgment. First is a writ of execution. This writ authorizes the seizure of the debtor's property to satisfy the judgment. It is often directed toward the sheriff or marshal, instructing them to seize assets such as personal property. There is also a writ of possession. This is applied when the legal action involves recovering specific property or real estate. This writ allows the sheriff or marshal to take hold of the property and transfer it to the rightful owners as determined by the court judgment. The more common one is the writ of garnishment. This is similar to a writ of execution. However, a writ of garnishment is specifically for attaching a debtor's wages, bank accounts, or other debts third parties owe the debtor. Through garnishment, money is taken directly from the debtor's source of income or bank account to pay the creditor. Oftentimes, to get a writ of garnishment, you will need to get interrogatories through the court. Interrogatories are forms the other side will fill out that have their assets, income, bank account information, work status, and other vital pieces of information. It is important to remember that after court, getting interrogatories, a writ of judgment, and other documents, you will need to have the other side served those papers as well. This is why keeping everything civil and as peaceful as possible throughout the process is good. Now, if you would like to know how to argue your case in court using the crack method attorneys use, then check out this video.